Also. Yes. Call that. Item fixed for 2 p.m. Item number 39. 39. Please partly. Well. I didn't hear. Item 39. Just where the validity and legality of exemption provision exempting a qualification prescribed under the section 23 of RTI, that is under challenge. But I have already earlier wrote. Yes, ma'am. RCFC Act. Right to Free and Compulsory Education Act 2009. But although earlier I had filed a compilation of Act rules. This is yes, sir. I am coming to, but I have kept in mind what is a highly contested matter. Why it has been mentioned to take up at 2 p.m. On that day, my lord was reached to. I didn't know. I just you said that admission of class 6 or something. Your lordship, after referring to the Gaurav Kumar case, also caution us within that 6 basic ingredients, your case is required to be made out. If at all it is possible. No, I have directed this. And 39 to 30. Your lordship, that is why your lordship was pleased to fix this matter. Now, will you argue or Advocate General will argue? No, sorry, Deputy Solicitor General or is a central act? Yes, ma'am. Yes. So you are challenging the virus of the state rule is a state rule which is framed in Advocate General will argue or you will argue? You will argue. Ready? Yes, sir. Section 9 petition has been released. I have just handed over the compilation of Central Act and rules framed by the state. My lord, you also posed me that question whether you will argue or advocate. I decided in challenge it will be better. I have gone through the. That's why, because the what is what I decided that I firstly thought that it must be a parent act. Then I asked learned DSG to take care. Now when you say the rules, then the Advocate General has to be asked whether he will argue or you will argue. So, right question. Anybody, I have no difficulty. Since some harass has been challenged, it will be better if the then I have to take time, my lord. The state is the implementing authority. If you want to argue about the virus, then I can give some time already. And you are not mad party. Yes, we are not bad party. Subsequent case is party. OP number 3, the ministry now is a matter of education department. Yes, ma'am. HIT ministry is not there now. It is Ministry of Education. You have filed any consolidated first sector or something like that? Because HIT ministry no is a organization the stand in the government of India. But in the meantime, that is happened. You not see me kindly 1 minute. In following the exemption provisions, what is the exemption? Exempting the requisite qualification which is required for recruitment as well as for promotion within the elementary cadres from one level to another level. That has been exempted in exercise of power provided to Article 309 and that has been issued. Particularly when the rules framed by the state government in exercise of power, section 38 of RCFC Act is governing the field, clearly stating that state is to make a request to the central government. It is the government to examine, thereafter exempt. It is the central government to examine. Can you place the parent act? Is for particular sect, not in intent. Yeah. Can you place a parent act? Can you place a parent act? What it provides? That in compilation I have given. Where is the provision under the Parent Act?
Yes, madam. The Right of Children to Free and Compulsory Education Act 2009.
Correct. Show us this. I got
The definitions that I have stated likely to be relied that I have mentioned. Elementary education. As in my compilation. If you
I do not want to go compilation. Elementary education is defined in section 2.
Elementary, it is 2F.
F. Education from first class to 8th class. Then
yes, madam.
8th class.
Then your lordship will find the 2N.
School.
2N.
Recognized school imparting elementary education include
established, own, controlled,
appropriate government or local authority, aided school.
We are confined to that, not
A
subsequent.
school belonging to a specified category, unaided school not receiving. These are the 4 categories. Then
But we are falling in first category.
First category means established, owned and controlled by appropriate government or local authority.
Yes, government.
Is a government. Then, yes.
Before that, 2A is the appropriate government, means central government, so also the state government. That is 2A.
Yes.
Appropriate government means in relation to school established, owned, controlled by central government or the administrator of union territories having no legislature, the central government. In relation to a school other than the school referred to in subclause 1, established within the territory of a state by the state government or union territory having legislature, the government of that union territory.
So it's the government.
Then you should kindly turn to section 8, man. That in compilation I have also taken note of,
yes,
which is likely to be. Duties of the appropriate government.
Correct.
Appropriate government shall provide free and compulsory elementary education to every child, provided that where child so and so. Your lordship may kindly turn to explanation. Compulsory education means obligation of the appropriate government provide free elementary education to every child of the age of 6 to 14 years.
Oh.
And I am coming to ensure all these things. B and G. Provide infrastructure including school building, teaching staff and learning equipment. G is the relevancy. Ensure good quality of elementary education conforming to the standards and norms specified in the schedule.
Correct.
Schedule is the backside, attached. Before that, your lordship may kindly turn to section 23. Page 12, section 23, qualifications for appointment and terms and condition of service of teachers.
Yes.
But may I read one? Any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Two is relevant. Where a state does not have adequate institutions offering courses or training in teacher education, or teachers possessing minimum qualifications laid down under subsection 1 are not available in sufficient numbers, the central government, central government may, if it deems necessary by notification, relax the minimum qualification required for appointment as a teacher for such period not exceeding 5 years as may be specified in that notification. It is the central government may.
That is as a stopgap measure for a period not exceeding 5 years that can be done. Central government. But after all, it is an obligation of the state to provide.
I will come to the rule also. Central rule, so the state rule. In the same parlance, they have what the criteria they have been. Provision is important. Provided that, this is very important. First provision. Provided that a teacher who, at the commencement.
Yes. If he does not have a qualification, he will acquire within 5 years.
But this was existing on the commencement of the act. The second proviso, but although we have relied, your lordship will find that the only time limitation that was extended provided further that every teacher appointed or in position, like of teacher at the time of commencement of the act. That means the all existing teacher is to acquire the qualification. And every teacher appointed or in position as on 31st March 2015 who does not possess the minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the right of children to free and compulsory education amendment act 2017, which came into force, it has been inserted with effect from 1/4/2015. Well, that we have enclosed in our annexure as an read fiction. In every read fiction it is available. My lord may then kindly turn to section 38, which is the general enabling provisions, page 16. Power of appropriate.
As the rule-making power of the appropriate government.
But we realize the appropriate government may by notification make.
Oh, which clause?
I realize that is the L manner, your lordship. The salary and allowances payable to and the terms and conditions.
Anyhow, the terms and conditions and the salary and allowances.
Section 2 and 23.
Yes.
Then your lordship, that it said the 3 is also. Every rule is to be laid before the parliament, and like of the state government while exercising the power under 30 is to lead. That is 3 and 4. 3 deals with the central government, that is to be approved. Thereafter it will be effective, and 4 is also the same manner. If state government in exercise of power of 30 framed any rule, then it is required to be lead before the assembly. But your lordship, what we left, my lord, the schedule, as per the norms of the schedule, which earlier we read in the definition in the clause, section 8, that is 2 categories. One from class 1 to 5, but another is 1 6 to 8.
What?
One category that is in schedule.
Where?
18, page 18.
Yes, that's a pupil-teacher ratio.
No, here the qualification has been also. Well, I will come to that.
Yes.
You know, 2 categories. 6 to 8 one category, then 6 to 5 is one category. But accordingly, your lordship will find by annexure 1 to my repetion, central government notified in terms of section 23(1), the NCT is the prescribed field. And after notification, NCT, who has been exclusively empowered to prescribe qualification, not to relax, he prescribed the qualification that is at annexure 2. Your lordship, in my spiral binding, that I have given even the circulars, they are relying and we are relying on the subsequent development.
Where is the circular? The spiral binding.
Small spiral. The big one is judgment, another is yes. Hearing close. Because he no has reserved for judgment. No. And it has supply copies.
But copy, if they say has not been supplied, how they will come to know? And these are the part of your pleading. Have you annexed those?
Yes, in reply, even in my all the documents are not in my writ applications. I have enclosed here this spiral binding.
Can you rely upon a new document which does not form part of the pleading?
But we have been made it. I will sort my letter. No. I will rely.
To serve then
you will serve because. And then I will sort. I will sort the next. By tomorrow, I will sort. I will sort by tomorrow. If there
I can appreciate what I perceived since last many years, that there are very voluminous documents which are annexed to different applications, which are filed by the parties, those are on record. In order to just avoid anything, they have made a compilation that these documents are already there. I'm just making a compilation so that. But here it appears that these documents were not filed along with the pleadings.
The important documents are part of the record, which now I'm going to rely. That is annexure 2. It is available here. That is also available.
But if you rely some more new documents which are not there, then they have a right to peruse. That's a valuable right. How can a person be taken to surprise? Something new.
But I have also enclosed a document they rely during the course of hearing.
No, that I appreciate that when documents are already there on record, for the purpose of convenience, you have made a compilation. No difficulty.
May I propose one? I will supply the copy, then we will on both the 5th.
On the last occasion, why you did not?
Yes, not.
Yes, no, not based on this. It is I will apply. Like you
Sir, you are a veteran in the profession. You should know that what is required. You are relying on a very new document. Maybe is a public document, but they have a right to look at it.
I will
We never come across in this way that it is done. One documents, compilation without serving a copy, relying.
We will sort by tomorrow. You will accept me for this one.
We can't do it in this way.
We must have to give some
What they have might have done, they have made certain relaxations, which according to him.
Currently, if you not
Give him one copy.
I'll sort. One copy is there since I have to sort the number of copies. I will sort.
Sir, you are appearing for the state, and you are appearing. Interveners means the teachers who does not acquire a requisite qualification within the extended time. I understood the moment he opens the brief. I understood that what he actually aimed at. That is what is understood.
Dispute is only related to teacher eligibility test, not the requisite qualification. Everybody is in possession of the requisite qualification. So far as passing of PET is concerned, since it was introduced by the NCT, which is the prescribed authority, in 2000.
This has been hovering around throughout the country.
Yes.
TET is there. NCRT is the authority who prescribes, and there are at least 4 judgments of the Supreme Court in this regard are there. We understood the way he started.
Yes. NCT regulation also makes it mandatory.
Sir?
Yes, we are also relying on that.
I had an occasion to deal with hundreds of those cases.
Already Soberton 3, I have already prepared my written notes and everything, man. So,
You are also challenging the virus.
yes.
Yes.
Yeah,
So at least we get the respite that we will not hear you because you have already filed your written. He will be the lead the counsel.
but our case, we have filed earlier. And he
He wants to say that he has.
No. Pleading, our case pleading is complete. Every counter, regional, everything is complete in our case.
But the catch in this case is 3-0 proviso will prevail or the provisions of the rule even framed by the state government is to prevent. The rule has been framed in exercise of 30.
It is not
Section 30. That is the crux of the issue, man. That is hit by the doctrine of occupied. There are many supporting principles of this case. No promotion has been made. Let it come on Thursday. I will bite tomorrow, my lord. I will stop that.
Supply after 18th of August.
Because your lordship will find that the state government has challenged a single bench judgment which has been tagged with this. That judgment was passed basing upon that exemption provision. And that has been tagged with this, and state government challenged on the ground that it violates the RT Act and the rules. Therefore, the state government has the stand, contradictory stand. That is why your lordship earlier ballot was pleased to tag all those matters to be heard along with the WA matter. In the WA matter, they are the beneficiaries of that exemption provisions, which the single bench approved it. And my lord, your lordship, while pending, the matter was pending before this court. But did my lord, the single bench approve that in terms of that? Yes, my lord. The
Approved.
my lord. And my lord.
I heard approved it.
No.
With this word.
But following the exemption provision, they are giving the clean sheet and they are giving the promotion. Even a teacher, your lordship, kindly appreciate, we are all entered with the TET qualification. Even a person entered 31st February 2011. Yes.
For promotions.
Excited.
Wanted to clear all the obstacles.
Now, government has come forward, but another development has taken place. Government has come forward, issuing a letter, instruction, that only TET candidate will be promoted, and their cases is subject to the result. Now, that has been again challenged in the single bench. That is why it is a case of thousands of teachers' future. That's why we pray, your lordship, any day, my lord, your lordship, fix it, I will come serve all the copies by tomorrow.
Lord, except the read petition, I have not received any.
But I have served an extra copy.
So let them serve all the
Yes, madam.
respective councils may serve all the copies, then I can.
Madam, central government is with us.
Monday.
Blood.
There are many fresh matters in there.
Yes.
So then you will come on Tuesday.
Yes,
Man, one thing, my lord. We have made a party to NCT. Let the NCT file a affidavit. No, same day. My lord, I am the petitioner of.
NCR.
No, NCT is a party, my lord.
Not a NCT.
No, my lord.
Espousing the cause of the NCT. They do not want to file article and why they have chosen not to file it.
Yes.
So why you are complaining?
Already said.
So, I hope
Adjourn to which it
this is different. You have nothing to not be provided against different form of action in Australia. That's why I discussed it. We also impact them.
24. 24, sir.